Right, let's turn to this now. Justice Minister Ronald Lamola has reopened an inquest into the deaths of anti-apartheid activists, Chief Albert Luthuli, Griffiths, Mxenge, and Booi. It follows representations made by the National Director of Public Prosecutions, which raised the 1967 inquests that did not consider certain mathematical and scientific principles. Justice Ministry spokesperson Crispin Piri joins us for more on that. Crispin, before we get into the details of that particular aspect, let's just have a broader overall conversation which people have been engaging you on social media. I suppose the decisions of the African National Congress led administration at this time, 2 weeks before elections, are always asked as to what is driving the timing. Is it elections or is it something else? When it comes to TRC matters, this particular sixth administration, what has it done to address those matters? And now people asking these particular three that you are announcing, are they linked to elections?
Yeah, thanks very much for asking that. I think it's a good point to start at. We must remember that, firstly, when it comes to inquests, we're speaking of processes that are initiated by the National Prosecuting Authority. It's a process that involves a strict evaluation of evidence that is placed before the National Prosecuting Authority by interested parties. And they evaluate that information, and then they would come to the conclusion that the minister must entertain this recommendation for an inquest, and the minister would then decide whether or not to entertain the inquest request or recommendation. In this particular instance, I might point out that the decision that was presented to the minister was presented on the 6th of May, 2024. So to suggest that it was lying around somewhere idly waiting for elections is obtuse at best. But moreover, it ignores the other inquests that have been in the pipeline. So the Neil Agate inquest that has already been finalized, Ahmad Timor, Dr. Imam Haroon. As we speak now, we have got cases before the courts. The COSAS 4 are before the courts. The matters before the courts. The cases being prosecuted. The perpetrators are being tried. Caiphus Nyoka in Benoni is also before the courts. The perpetrators are being tried. So all of these cases are not as a machination of a particular electoral process that is about to happen. It's a culmination of a number of processes, and government doesn't stop on the verge of an election. It continues, and it must, because ultimately government must be there to serve the people, regardless of whether an administration is exiting or entering. They must continue to do the work. But also, Tawa, I must say this, and I said this on Twitter, and not to the joy of some people. When an institution like Stats SA points out that unemployment has increased by 0.8%, and it's of a structural nature, we don't say this is bad for elections. We commend them because they're a state institution doing their job. So likewise, when the NPA presents any matter at any point in time, we must commend them because they are a state institution doing their job.
So, I mean, while we're there and the independence of the NPA, there are some who would say this is not a new matter. For example, the matter of Chief Albert Luthuli. Even the family saying, well, we've been raising concerns about this way longer than the 2022 when the investigations would have started. And is there a thing of saying, well, the NPA felt maybe at a particular time it was politically undesirable to pursue the matter, and now it seems it is?
Look, that's a question that's currently being debated in the public domain. We don't actually have facts on the table that say X person. In fact, the people who claim that there was such an instruction have not gone further to say, I was instructed by this person and I'm now laying a case so that I tell people that my job was being interfered with. And that's what the NPA requires of you, the NPA Act. It requires you to open a case and say that, someone is interfering with the NPA and they must be prosecuted. But nonetheless, also, Tabu, I think we are here now, it's the sixth administration. The number of inquests that we have opened speak for themselves. And this administration has said it's important that we are able to get closure on these matters. We understand fully what has happened. And if there are people to be prosecuted, let them be prosecuted. That's what these inquests reveal. You would have seen with the Ahmed Timur inquest, ultimately led to the prosecution process of João Rodrigues. Who knows what these other inquests will reveal? At the end of the day, justice must be seen to be done, and it must reach its full fruition. But we must also be wary of making ourselves as though we are somewhat exceptions to the rule when it comes to matters of this nature. I'm sure, Tabo, our viewers have seen on a number of occasions, to this day, still in Germany, you hear of people being prosecuted for the Nuremberg trials, and you see sometimes a 90-year-old or a 93-year-old being dragged to the courts to go and account for matters that happened when Hitler was still alive. I mean, Hitler's long dead. Some of us have never even seen what Hitler looks like, but people are still being tried for Nazi crimes to this very day. So we must actually commend the resilience of the system that it's going to pursue apartheid perpetrators because this was a crime against humanity
Yeah.
to their graves if needs be, right up until. But there shouldn't be a time bar on when justice is delivered.
So let's then talk about the representations, shall I say, that were made by the NPA to the minister to look at, for him to say it's necessary to reopen the inquest. What are the mathematical and scientific principles that are not making sense, as they say, the numbers were not numbering, when you're looking at the reasoning given that this would have been a train accident and what you're looking at?
Yes, in the case of the first African Peace Nobel Prize laureate, Chief Albert Luthuli, there is in fact that evidence that is on the table. Some of this involves what a person who would have been hit by a train, the type of velocity at which they would have traveled at, the type of damage that they would incur as a result of them being hit by a train. All of that is on the table and was duly assessed. For example, one of the issues that were looked at was the hemorrhage, brain hemorrhage that would take place. And the evidence as we see it and as has been presented by the experts to the National Prosecuting Authority does really point to a questionable conclusion that the inquest in the apartheid days had reached. So that's one of the reasons why the minister has agreed to reopening the inquest, because on the face of it, that evidence must be tested by a court so that they can really draw scientific conclusions, or draw rather proper conclusions that really point to a conclusive conclusion around what happened on that fateful day in Stanger.
So it's a bittersweet moment for the family, from what we hear from them on two senses. One, it's good that finally it is happening because they've been calling for it. But two, it's bitter in the sense that they think that the people otherwise that would be the ones held responsible for this, some of them have either died, some of them are too old, even that evidence might not be as reliable now, 57 years later, than it would have been a little bit earlier on. What do you say to that?
Yeah, we are very sympathetic to that view, and it's quite right that, of course, by now it's very well possible that the perpetrators are long dead. But I think the overall process of fully understanding what happened in and of itself is something that we should pursue. It's something that would give all of us, the entire nation, and the family closure, because as it stands now, there's a question mark around what has happened in that incident.
Yeah. And in the matter of Griffiths Mxenge and the boy Mantyi, it's a completely, well, I mean, not completely different, but it's a different set of representation and circumstances that you are dealing with here that are causing you to agree to the opening of the inquest. Just expand a little bit on that.
Yeah, in the Griffiths Mxenge case, we do know who the perpetrators are. We do have a confession that came through at the Truth and Reconciliation Commission. However, there is an aspect of that testimony at the Truth and Reconciliation Commission which the NPA feel still leaves much to be desired, and we perhaps can investigate who exactly was at play, because what we have before us points to certain individuals, but there was an open-ended question around what I think the fellow goes by the name of Terkutsia said. There were special forces who they worked with to actually assassinate Griffiths and Mxenge. And so the NPA, in its assessment, is going to really hone in on who are these special forces, because upon re-evaluating the testimonies at the TRC, that is not a question that was interrogated thoroughly for all of us to understand who were the special forces that were worked with in the Griffiths and Mxenge case. In the Booi Mantyi case, what has emerged is that the version that was before also the TRC to some extent was not conclusive, in that it has now emerged that there was actually a witness that witnessed this incident. And so the conclusions drawn from there can be revisited, because we now have a truthful account, possibly, or there's a possibility of us having a truthful account of what truly transpired on the fateful day in which Mantyi was assassinated.
Yeah. To somebody who says to you, Crispin, that, look, there are murderers today who walk free simply because the investigations are not coming up with sufficient evidence, or they cannot find, the necessary people. Maybe they are not in the country. Others have escaped and gone elsewhere. What is the use of using the resources of the department in particularly pursuing these cases, which are also likely either going to be following a date trail of evidence or individuals that can not be held criminally culpable because they are no longer living?
Yeah, there are two answers to this question. The first one is, this is precisely the conundrum that we deal with when we have to put resources in place to investigate cases that have happened. We're now talking almost even 50 years ago. Ideally, what we do want is to put all of our resources there to investigate crimes that are happening now, and we have the best possible teams to be investigating live cases and crimes as they happen in this day and age. But justice does demand that we close that chapter conclusively and we know what has happened in those cases. And like I gave an example, even in places like Germany, you still have teams investigating Nuremberg trials and Nuremberg testimonies. So we're not unique in that regard. It's not ideal. I mean, most countries don't have such historical problems, but given the nature of our country, we have that unique problem, and we must address it square on. And so we have put in significant amount of resources to address this issue. Each division of the High Court has got a special unit that investigates TRC matters in the NPA. But the second answer to it is that ultimately what you want to ensure here is that we have a system that is able to address any form of injustice at any point at which it takes place. And there are cases to this day, yes, of people who say, look, I've been wrongfully convicted. And we have a tool to address that. Section 327 of the Criminal Procedure Act allows you to present new evidence to the Minister of Justice in terms of the act, which says that, look, I'm wrongfully convicted and this is the evidence that I can point to. Revisit my trial or ask the court to revisit my matter. And the minister is empowered to do so. I think at the next time we can chat, I'll show you the number of instances where the minister has possibly considered writing to the various judge presidents of the High Court to consider that type of testimony or that type of input from an inmate. But also, we now have in place, of course, a democratic state. So by the time an individual gets prosecuted for a crime, for finality's sake, most of the time one is afforded the possibility of even appealing a particular sentence. So we live in a very different era where, with the assistance of good state legal representation in the form of legal aid, one is able to take up matters right up to the highest courts in the land. I mean, there was a matter the other day which was involving the IEC and so on, and they were quoting cases brought by prisoners around what parole truly entails and what the effect of parole is. So access to justice in our constitutional democracy considers that. It means that you could also then have an opportunity to challenge a court decision right up to the highest court in the land.
Of course, whenever we speak TRC cases, the next question, of course, is TRC reparations. And some victims still sitting today saying we are still demanding reparations. If we are going to do this and not get to a point of reparations when they're saying there's some 2 billion or whatever that is sitting unspent, again, it begs the question, why are we doing this?
So that's the narrative that is being pushed by a group called Kulumani. Depending on who you speak to, others say that's not the real Kulumani, there's another Kulumani elsewhere in the country. And we have engaged that group several times. One, we went to them at the Constitutional Court where they were protesting, and we said, we understand you are here to protest. Can you explain to us how you are TRC beneficiaries? Because the TRC process identified a number of beneficiaries. One, you had to present yourself to the TRC officers, and then at some point you were called to testify and explain how you are a victim of an apartheid crime at the time. And then from there, the TRC would then make a decision as to whether an individual is indeed a TRC victim, and then they would then say this person is eligible for reparations. That decision was then endorsed by the Parliament of South Africa. And so all of the TRC beneficiaries are contained in the TRC report, which was filed to President Mbeki, I think, in about 2003. Some of those individuals at the Constitutional Court, as we speak, are on this list. We've confirmed them. They are receiving whatever reparations that are due to them. Some of them we identified there may have been a glitch. For example, different name spelling and slightly different ID number or slightly different address and all of that. There were attempts to address that. But this notion that in the Guardian's funds, actually it's the President's fund, there's 2 billion rand that's just sitting there gathering dust is not true. One, you, Thabo, would be the first, and many of your other colleagues, to haul us over the coals if we allocated money to individuals who are not earmarked to receive that money. That would be a classic case of corruption. What would be the basis of us allocating state funds to people who are not required to receive these funds? But two, those funds are there and are constantly being dispersed for education for TRC beneficiaries. They are constantly being dispersed for medical health care, although some of the regulations that are required have not yet been finalized. But there are people who have been identified to be able to receive healthcare funding when necessary if they have wounds from the apartheid regime era that were occasioned by conflict, and this requires some very sophisticated operation. There is a special regime in place for that. And the last one is housing. There are some housing reparations that are set aside, and also the regulations with the Department of Housing are yet to be finalized, but it's work in progress. But importantly, the reason even with housing and healthcare is that in modern day South Africa, we have access, either you qualify for an RDP home, you qualify for free education, or you qualify for free healthcare. So those reparations are being, particularly these ones, these individuals are afforded these amenities regardless of what their status is. So it's a narrative that is being pushed by people who we think it's very sad that we have people sitting there at the Constitutional Court demanding reparations for a process that long closed. And we've tried numerous occasions, Thabo, to explain that, look, we can't revisit a parliamentary process as the executive, because the minister represents the executive.
Right.
Perhaps it's a conversation that we must have with parliamentarians to say, you finalized a process in 2003 that was flawed. Consider reopening it so that we can benefit from these reparations. But then the question begins is, where do we start and where do we end? Because there may be a flood of people who say, I didn't make it to the doors of the TRC, and I also deserve reparations.
Yeah.
And then what do we do?
Crispin, appreciate your time. Thank you very much, as always, for coming on. That's Crispin Phiri there, speaking on behalf of the Ministry of Justice and Correctional Services. Right, let's take a break. In Focus continues with your news in a moment. Stay with us.